it felt good because that's what our profession's supposed to do. We're supposed to help everybody because rising tide lifts all boats, right? And we hear that all the time. And I know you share freely, I share freely, like, because when you help somebody else, they're going to help you when you need it. And the defense does not work together. They don't help each other. They don't know some of the dirt that one of the defense lawyers was able to find it and share it with the other lawyers. Whereas we know everybody's dirt because we all work together.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, before we get into the podcast episode, I want to take a minute or two and introduce you to a friend and colleague, Jenny Shadini. Jenny is a former prosecutor from Baltimore City, and now she works as a settlement consultant. We work with her often on helping our clients really maximize their results. Jenny, it's really great working with you and having you as a supporter of the podcast.
Thank you, Sharif. Hi, everyone. My name is Jenny Shadini, and I work as a settlement consultant, which means I work with attorneys and their clients in various settlement planning needs, such as structured settlements, whether or not to utilize a trust, how to protect government benefits, and overall providing financial security to your clients.
And Jenny, how could people get a hold of you?
The best way to reach me would be my cell, which is 301-332-1031. Again, that's 301-332-1031.
All right, we're back, RVA Trial Lawyers, and today we have a good friend of ours, Tarun Rana, joining us from St. Louis. So Tarun and I actually met through another podcast guest, Chris Finney, a few months ago. Chris and I, who's a good friend, were chatting about an upcoming trial that I had against Ford involving a carbon monoxide poisoning with one of their vehicles. Very, very difficult, challenging case that ultimately did not go in our favor, unfortunately, but hopefully we'll have some good grounds on appeal. But anyways, in talking to Chris about that case, he said, hey, I've got a buddy here who he won one of these carbon monoxide cases. You got to talk to him. So Chris sent me Tarun's information. I connected and with Tarun, and Tarun gave me everything he had. And we spoke multiple times before the trial, after the trial. And so Tarun, you were a massive, massive help in preparing, not just substantively, but also saying, hey, you can do this. And so we put on a hell of a fight. Unfortunately, it did not go our way, but really glad we had the opportunity and really grateful that you assisted us any way you could beforehand. So definitely a privilege to have you on the podcast. Really excited to learn about your practice, learn about your approach to trial work. But before we get into all that, I think I want to learn a little bit more about who you are. So if you wouldn't mind sharing a little bit about yourself with our listeners, that would be great.
Yeah, thanks so much for having me on. And I'm super excited. I'm glad Chris put us in touch because, sorry about the the result, but it doesn't take away the immense work and the passion you had for that case. So, unfortunately, sometimes they don't go your way. And that was one of the things we connected on is, after your loss, we kind of talked about, hey, one of the big things is, losses actually help shape us. So that's what we're going to talk about partly today. But a little bit more about me. I'm here in St. Louis. I'm licensed in Illinois as well. So I started my practice here in St. Louis. But after school, I went to Chicago for a bit. Ended up coming running back because Chicago was not for me and it was too busy and expensive. So I came back home and I worked for a firm in Chicago. In 2009, there was no jobs out there. So I was very fortunate, got a PI job there in Chicago, came back, got a PI job here, worked for various firms, and went out on my own in 2012. And basically been just kind of hit the ground running since then.
What was it about PI that hooked you? Because in full candor, where I went to law school, I didn't, and maybe this is because I wasn't the greatest student, but I didn't even know what PI was. I didn't even understand what torts was until the week before the final exam, where suddenly I looked at this outline and it was like, there's this thing called duty, then there's breach, then there's causation, and then there are damages. I'm like, now it started to make sense. But what was it about PI that got you in so early on?
So funny enough, I don't have that sexy, hey, I went to law school because I always wanted to be a lawyer thing. And I got into PI because I always wanted to do a thing. It was kind of what fell into place. So my first internship was with a solo practitioner who did personal injury. And it was very shaping because he did all the things a certain way. And I'm like, okay, this is interesting. But imagine if I had my organization, my business acumen to make this an even better firm, and I could do that. And so in the back of my mind, even back when I was in law school, like at some point I could see myself running my own firm. And, truthfully, you also hear personal injury lawyers, the 10 wealthiest and 10 poorest attorneys in any town are personal injury lawyers. So I was drawn to the money side, but no, it was just one of those things where then it also helped. I like helping people. And it was one of those things where I knew I could help people, and specifically people that couldn't necessarily help themselves because they were up against a corporation, an insurance company, a commercial defendant, and they kind of need, like, I'm small, I'm 5'4", I'm kind of a big guy, but I'm 5'4", so I kind of always have the little man mentality. So it's like, whenever they come to me and trying to act like they're tough and all this, I'm like, you're not scared of anybody. And that's kind of fun for me, because I always get really underestimated because I'm kind of a smaller guy. And I kind of rope-a-dope, and that's kind of been my MO. It's been very successful because I'll get to trial and they're shocked that I'm like competent and actually know what I'm doing, and not just like this friendly guy who kind of jokes around. And I just like getting underestimated. It's fun.
Well, there's that whole like David v. Goliath aspect of this work that's incredible. And I think we were talking before we started the episode, but I did a lot of criminal work before this, so much so that like when I thought that I was a criminal defense attorney for life. And I mean, I still like that work, and occasionally when I can, I'll still assist, but we're busy enough with personal injury, knock on wood, for now that we're not doing that type of work. But it was that David v. Goliath. It was the fight the man. It was right to right the injustice. And when my eyes were open to that same dynamic in personal injury, I mean, I knew that, like, wow, I might find a home there. And it sounds like you're similar. Yeah, so I'm 5'6". I plan to be 6 foot here in the coming future. But
I'm waiting for that growth spurt, my man. But yeah, you and I were talking before, and you mentioned, the Keenan stuff really kind of got you hooked on, the actual background of tort law. And yeah, I teach with them, and that's kind of where in 2012 they had like Welcome to the Revolution, and that's when the Keenan stuff really hit with him and Ball. And they came to Kansas City, which is just across the state. And I mean, it took off, and our Missouri listserv was like one of the best. I mean, we were like, everybody was just kicking butt. There was great verdicts coming through. Like Finney was crushing it. We have so many good lawyers here, and they collaborate so much. It's so awesome. And you're absolutely right. Like we kind of set the tone for, helping out with deterrence and all that. And that's important.
Can we talk a little bit more about that?
Yeah.
So just the fundamental approach that those who kind of go through the Keenan methodology, the reptile methodology, really embrace?
Yeah, so I would say I still love the program. I think with everything out there now, you really have to just kind of go to various, like, you really just got to absorb it all. Because I think COVID was awful on many levels, but one of the great things about COVID is all the CLEs just kind of kept popping. I mean, you got to hear from everybody. So with Keenan, they kind of started the process, and then after that it kind of exploded, and then everybody got in on it. But essentially there was multiple classes from, just the rules to case selection to damages, which was the one where I met Russell Button, who we were talking about before, with his daycare cases. And then, so he taught damages, and then I started teaching damages for a bit. But what they do is they put you through various courses in various systems, and you learn pieces of the puzzle. And then when you put it all together, it really creates a very effective trial method. Now, of course, I dabble in everything now. I'm doing Mitnick, I'm doing reptile, I'm doing, so now it's called Edge, but, I'll do Sash Oliver, I do TLU, I do everything that's out, Paris law, everything that's out there. We have such a strong resource for everything that it's easy to do it. And we're kind of getting into, the stuff that I would recommend people do, but that's number one, is just go to everything. There's so much out there.
There really is. And I think in doing so, you then develop your own toolkit, right? Like, You're never going to be Keith Mitnick, and nor should you ever be Keith Mitnick, right? Exactly. You need to be the best you. And by being able to go, and actually something that I've noticed, Tarun, is that I have been fortunate enough, and my wife patient enough, which that may end here soon, to go to a bunch of these different, wait till she finds out about, hopefully she doesn't listen to this episode. So wait till she finds out about my trips this fall. I promised, I was like, all right, I'm done. Cause I spent 3 weeks in Texas for that trial. I went to, where else did I go this year? I don't even know, but a handful of places, right? I've been to Texas 3 or 4 times this year, which is crazy. And all of a sudden, Kenny Berger's doing his thing with Trial by Human in September. We're doing our thing in Richmond, which super grateful that you're coming to.
I'm excited.
It's going to be a blast. There's Satch Oliver has a thing in Fort Worth for depositions or trial, which I can't wait. And there might be one other thing in LA, which I don't think I can pass on. So anyways, so her patience, I'm sure, is running thin. But one thing that I've learned is that those who seem to be doing a really good job with their cases and getting results consistently, they have a lot in common, right? They're trying the conduct of the case. They're finding and trying the lie. You can see that they're borrowing from all these different approaches and kind of creating their own thing, which of course you can't copycat, but like there are these similarities. And I really think that the fundamental similarity is that reptile Keenan edge approach, which is that defendant's conduct is what drives damages, that that's what motivates juries. And so deterrence and pursuing deterrence in our trial strategies is really the mover and shaker. And it makes it very difficult in your admitted liability kind of soft tissue cases, incredibly difficult, right? And actually, before I be quiet, there was a guy named Ben Gideon who I listened to his podcast with Rahul Ravapudi. And I remember seeing Ben at Trial Lawyers University, which is something that was actually a product of COVID. Dan Ambrose created that during COVID. And I remember Ben giving a talk, and one of the quotes that I wrote down was, he said, and hopefully I don't butcher it, he said, verdicts are to deter conduct and damages are just a means to do so. And in my mind, when I heard that, I was like, that's Keenan, right? That's it. That's the entire thing. Is that right?
Oh, absolutely. And I don't know if we're allowed to curse, but Bubba don't give a shit about our client, and that was always the refrain, right? Like, Bubba don't give a shit about our client, which is so true, because right now I'm supposed to be in trial in 2 weeks, and we just found out that we're going to end up getting continued. But I did big data, I spent the money. That's a big thing that I actually recommend. I've done it on all my big cases, and it's been invaluable. And what I learned is ultimately you got to have that bad conduct, because what that does is then the jury is willing to then talk about money. Because if you don't have that bad stuff, they're like, okay, what's this thing worth? And it's always less than, if this is in isolation, they say, well, your person can walk. If they're not walking out of here in a wheelchair or in a body bag, I'm not giving any money. Where if you get people sufficiently mad enough because of the conduct of the defendant, or you try to lie, like you said, the three-legged stool on, the emotional buttons are so important that we learn in Edge. But if you can hit those, then you're going to get the jury interested. Otherwise, it's an event case versus a system failure. And if it's an event case, they don't give a crap. They don't care.
Right. And then to dig into that a little bit more, right? Like, event is a single incident, right? Whereas a systems case is when you can show that there's been systemic failures and you're giving the jury an opportunity to make a change by way through their verdict, right? And that's when the jury can use their verdict to influence conduct. I think that's when we start seeing larger verdicts. Yeah, I mean, I think we're seeing that, in being in Missouri, we're getting hit with a lot of the Monsanto stuff. They were bought up by Bayer, but I have friends that work for Monsanto, and they're like really mad that these verdicts are taking place. And, what I don't tell them is, listen, there's 12 people sitting and listening to this evidence, and they're given a huge verdict. And they're given a verdict not out of sympathy or because they're runaway rogue juries. They're given money because of what they're hearing is pissing them off. And when they're giving this one person a bunch of money and a bunch of punitives, because in St. Louis, they're really putting up billboards trying to defend Monsanto's actions. And it's like, even with that jury tampering, they're still getting these verdicts. These plaintiffs' lawyers, like I think Nick Rowley tried one out here, and Lanier tried one, and they're getting big verdicts. And there's a reason, because people are mad, and it's hitting their reptile. What the hardest, and I've never encountered this, but the absolute hardest defense that I think we could ever encounter is at trial, defense attorney stands up and says, guys, we're so sorry we're here. We take full responsibility. We recognize this person was hurt. We believe in that this plaintiff deserves compensation. We do disagree with the amount, but we by no means at all hide from what happened and our responsibility for it. I don't know what I would do as a plaintiff's attorney.
It's happened to me once, and it anchored the number down. But the reason they don't want to do that is because I think it springboards to the opposite, which is, well, now it's got to be a big number. Because the problem is they always have an asterisk there, right? They always have the asterisk, which is, but give them no money or give them close to no money. And that's where they get like 90% of the way there, and they don't want to go that extra 10, because the opposite is they go that extra 10 and give them a fair amount. That fair amount could be 7-8 figures, which is what people deserve for some of these injuries.
There's a good friend of mine. He's a defense attorney in town, and he defended a case a few years ago. Horrific facts. I mean, we're talking a young kid. I mean, bamboo went through. Growing, right? Like, just absolutely awful. And I certainly wasn't there, so I wasn't in the jury room. I didn't have an opportunity to watch the trial. But in talking, and I know the plaintiff's attorney well, very, very incredible young plaintiff's attorney, and I also know I'm friends with the defense attorney. And hearing how the defense handled that case, I was blown away. I mean, he got up, he told me an opening statement and said, "We're proud of this plaintiff," right? Like, and I think in doing so and kind of following that trajectory, I'm guessing he probably kept the number. I mean, the number was still significant. I mean, I think it was a $10 million verdict.
Yeah.
But worth it, right? But I wonder though, had the defense attorney in that case taken the approach of let's just fight everything, I wonder if the verdict would have been hundreds of millions, right? So anyways, well, enough about that. I want to hear more about your practice.
Yeah. So solo practitioner, went out on my own in 2012. And, then at that point I was taking everything. I was doing domestic, I was doing traffic criminal. I was doing referrals from our local bar association where it was reduced fees. So, I mean, I was doing like $50 an hour type work. And I was getting referrals from one of the big advertisers in town. And what I was really doing was building my book of business. So that's where the business side really, really springboarded, I think, for me, is I was just building my book of clients. And even today, I got a call from a client that I've had for ages. And that's what I built is over the next 13 years, I do no advertising. Like, people are like, well, why don't you do Google ads or whatever? I'm like, I don't need to. I got all the business in the world because I built such a good, strong, organic referral network between, the doctors, the attorneys, and former clients that I'm able to get a lot of business that way. And I do 95% personal injury, like 3% work comp, and like 2% like traffic tickets, BS stuff, just to keep the lights on for really just to stay in front of clients. To be honest, we don't make any money on traffic, but in order to stay in front of clients. So as far as attorneys, I'm the only attorney right now. I had a gentleman who was perfect. So we mentioned Chris Finney. He's got an Alex Ledbetter, who's like a brilliant, really good research guy who is just a great warrior that Chris has that helps him with a lot of the stuff within his practice. I had a guy like that who was an older guy who went back in. He was a head of quant for one of the local banks. He was a super smart guy, retired early, and went to law school for fun, got a full ride, was number 2 in his class, and then he came and worked for us. It was awesome. It was the perfect fit. He unfortunately retired, so I'm in the market for a new attorney to come in, but I'm the only attorney right now looking for a number 2, and then I have a lot of support staff. So that's kind of how I've managed to stay lean. Our overhead is very low because we don't spend a lot of money on stuff, but we have a very good practice. We make a lot of money, we just don't spend a lot, which is the right way to do it, in my opinion. Because I know one of the questions you asked down the road is, hey, what advice do you have for people that are looking to get into it? Be lean and save money. So I pride myself that we do that really well.
Well, you put money where it matters, right?
Yeah.
I mean, you don't need a $3,000 desk.
Right.
You just don't. Put the money into keeping people happy and quality colleagues, right? Like that's what matters.
Exactly.
Yeah, that's awesome. Now, is there a certain trial that you've had over the last few years or so that kind of sticks out to you as memorable or at least instilling some sort of lessons that you've taken?
Yeah. Let me give you the brief facts on it because it'll help. It really helps me. Yeah, it was actually the loss that I told you about because it was one where it had difficult facts. So basically, there was 3 cars on the highway, And my client is a little boy in the middle car. And in front of him, the front car crashes on the median on the highway and then creates an obstruction in the road. My client, his dad is driving. We don't know. He either stops behind the car in the fast lane or he rear ends that car. A third car comes and smashes into all of them. My little boy is very hurt. He ends up having a moderate TBI with a skull fracture, orbital fracture. I mean, he's messed up. Like his face is just destroyed. And he goes to the emergency room, gets a lot of reconstructive surgery. So damages were very large. Liability was thinner because each of the three cars only had $25,000 in coverage. And so dad, middle car, and rear car automatically just right away tendered their 25. I didn't accept it, but they tendered it. The front car denied the case twice. They said, well, hey, the other two cars accepted liability, go after them. And Missouri is very strong on open policies. And I don't know if you guys have an equivalent, but basically,
We're not.
You're not?
I mean, we have it, but like it's more of a fictional conversation than it is a reality.
Missouri is fantastic for it. So I've been very fortunate. I've got a lot of excess verdicts over the policy limits or even settlements where the policy limits were X and we got X times 9 because they just messed up. And so here, this ended up being a case where I asked for about, I think, 20 or 30 million at trial. And we got zero, unfortunately, because of the liability side. But it was a case where it went from a 25,000 max to open. Like we couldn't have asked for anything. And so why it was so helpful and why I'm using it as an example here is I learned a lot of really big lessons that then springboarded into some of my biggest settlements to date. One of the things I learned is you got to let the defense make some money. They got to work up the file. And if you keep them busy and by extension you stay busy, it kind of makes the whole thing get to a position where you're either going to be in the best position to settle the case or try it because you put in max effort. That was one of the biggest takeaways is how just each side can keep each other running, and it's to the benefit of both sides because then everybody is putting forth their best case, but then the defense is getting to bill their hours, make their money. But we ended up going only against the front driver because in Missouri we have a really good law on this as well, which is I settled that with the two rear cars. And if you settle that with them at trial, we can say, hey, we just believe this front person, the person who crashed in the front, is partially at fault. And if they're partially at fault, then you vote for us. And if so, they're actually on the hook for the full verdict. And I think that's kind of what led to and ended up being kind of difficult for the jury is they ended up zeroing us out because they just could. So the reason the front guy crashed was he had a diabetic episode. And we had monster evidence showing this guy was like an out of control diabetic. He knew about it. He had all these red flags. And I was really proud of the work we did in showing that he was not a good diabetic. And we really tried to be nice because it was this nice old guy. So, I had to be soft. But what ended up happening is the jury just didn't like that dad stopped in the highway and they put all the fault on him. And to the defense's credit, that was the argument they made is they should have never been there. He should have pulled off either direction, but never stopped behind and created this problem. But I learned more lessons, but that's kind of an intro to the case.
Before we go a little bit further, could you talk a little bit more about what is an open policy and like how do you set it up?
Yeah, so we have two ways in Missouri. One is a statutory route, which I never go, and then a second route, which is you offer to settle within the policy limits, whatever they are. So let's say somebody has a $25,000 policy. Typically I would demand 50 and say, or the policy limits. So now the insurance company has the opportunity to settle within policy limits. If they reject it, it is a business decision that they make. And then they are on the hook for potentially if more is obtained down the road. So I had one case where there was a $50,000 policy. My lady was getting surgery. They didn't offer it. And then down the road, they ended up paying well over the policy limits because an insurance company has to take the interest of their insured over their own. And when they make the business decision not to pay limits, that is a business decision as opposed to one in the interest of the insured. And so if they expose their insured to more money, since they initially made that decision, they then are responsible for it in Missouri.
How do you time that demand?
We do what's called commercially reasonable amount of time, which is typically 30 days in insurance lingo. According to the insurance regs, it's roughly 30 days. So most of the time, every demand we send is within policy limits, unless it's like, a $3,000 in meds, nothing case. No, we can't do that. But assuming it's got a little meat to the bones, we always ask for policy limits because it really makes the insurer have to decide, is the case worth less than the policy limits? Because if it is, they really ought to try to settle it. And if it's something that might have more exposure, they're then exposing themselves. They're essentially writing a blank check.
Is there a certain stage of the case at which you can do it, or can you do it anytime? And
you can do it any time, but there's certain rules.
Let's say they haven't learned enough, right? Could you do a pre-suit?
Yeah.
But the insurance company doesn't have enough information to really evaluate the case.
Yes, with one caveat. So you always want to make sure you give them enough. So there's been times where we send a demand and they ask for more information. And if it's a legitimate request, like, hey, for instance, your client has history of a bunch of prior stuff and it really overlaps, we kind of want that. I then have to decide, hey, is that legit? If it's a legit request, we usually try to comply, because I err on the side of more paper, because I want the future jury, which thankfully I've never had to do this, but if there's a potential bad faith case down the road, if they say we're not going to pay the verdict over the policy limits, this then goes to a bad faith case, which is totally different, but essentially a jury is reviewing the actions of the insurance company. Well, that's where I want to be very cognizant of the fact that everything I put in writing may be scrutinized by a jury, and everything I've done supports my request to show that the insurance company was acting in bad faith. And one of those is to decide, hey, are we giving them enough? So you can't just say, hey, you have 3 days to pay the limits and here's no info. You're never going to win that case. So great question.
This maybe sounds a little trivial, but let's say you give them everything they need to justify policy limits, give them a 30-day demand, and then they don't pay it, but day 35 they do. Do you have an open policy there? How does it work?
That's a field question. I err on the side of papering. So the 30 is more of it's not a set in stone, but I do calendar it out for 31 days and I say, hey, I haven't heard back. So again, we have to be somewhat reasonable. There are some attorneys that say, hey, you blew it, I'm filing suit. I always try to appear reasonable, which is, hey, I'm disappointed I haven't heard back. I gave you everything you wanted. I kind of put everything here's when I sent it. Here's when I expected a response. I didn't get it. And I kind of leave it vague, because then it's not me saying that. It's more like I'm the disappointed dad, that kind of thing, versus kind of hitting them with a stick. And then it's up to them to maybe tender the limits. Now, if they tender it, most of the time it is in our client's best interest. Now, if this is a clear cut, you should have paid, no, I'm going to pull that trigger much quicker and say, you blew it, now we're filing suit. But again, we have to think of that future jury. That future jury can be like, well, that wasn't reasonable. You should have given them 5 more days or whatever. It's kind of a feel thing. I've been very fortunate because I've had so many excess settlements and verdicts that things have just fallen into place. But I think the common thread is a lot of paper. So I'm sitting here like a keyboard warrior, just papering the crap out of the file.
Now, let's say you, practically speaking, you get an excess judgment or verdict, right? And it's a separate action at that point, right? Do you then have the defendant assign his rights to you for you to pursue the bad faith claim against the insurance company? How does that work?
Yeah, no. So what's I've been very fortunate. I've done, I think, around 20 trials, and probably over half of them have been excess. And all but one, the insurance company, after kind of doing their post-trial motions and losing, they ended up just paying. They just covered the verdict, because we are very good about papering the file to protect the insured. At the time, the insured doesn't know that we're protecting them, and they think we're the scum of the earth. But afterwards, and I don't know that they ever figure it out, but we've actually protected them more so than their own insurance company and their own lawyer that the insurance company hired for them. But the one time it didn't pan out, they only tendered the limits. We then, the insured got their own separate counsel. We linked up, and then we ended up resolving the case at mediation for the full judgment. But I'd say it's rare for me. I know it's happened from time to time, but most of the time in Missouri, they will just pay because it's the smart thing to do.
That makes sense. Well, it sounds like you guys have some strong law on that. We do not in Virginia, and I've certainly tried, but I haven't. I have not. my colleagues have told me that they've had results that are excess and that the insurance companies typically will just pay it, but I haven't experienced that before. And also there's a lot of debate over, well, I mean, if the medical specials aren't high enough, were they really on notice that this should have actually been a policy limits case, right? And so anyways, it goes back and forth. But anyways, instead of going down that rabbit hole, let's go back to that case and some of the lessons you took away from it.
Yeah, so I think one of the main ones that I learned pretty early on was trust myself. I do feel that I've gained a decent amount of expertise in access open policies. And what I learned is a lot of and I'm 41 now. And so when I kind of started that journey, I was probably, 37 or so in that case. And at that point, I still knew a decent amount about open policies. And I remember, so trust myself is the takeaway for number one is, I got a call from a guy with, a partner at a big defense firm, and he basically, in so many words, said I was an idiot and didn't know what I was talking about. And he sent me a big, long brief saying that I was wrong about the law and all that. And I'm like, no, I'm right. And I never heard from him again. And then they hired a lawyer, and then she said the same thing, like, hey, you know what you're talking about, there's an open policy, blah, blah, blah. And then when they were later making offers well outside the policy limits, it's like, I should have really believed that I was right, and I should have trusted myself more. So I would say that's number one takeaway is trust yourself, because we know our stuff. We are better than them. They're inundated with so much work, and they're doing the same old stuff. We're going to conferences and learning cutting edge technology, and all the stuff. So believe yourself. So that's number one. I would say the other big takeaway was, and it kind of goes with the Satch Oliver. So I actually didn't know about the conference that you're talking about with Satch. I may look into it and see if I can go. But
yeah, depositions or trial. It's like the first weekend in November. It's in Fort Worth, Texas. It looks awesome.
Dude,
so
I'm going to check it out. I've got a trial set then, and it's right around my birthday. We'll see if I can make it work. I'm going to make it work. But that's what I was going to get at is there's so many materials out there, but the deposition or trial was kind of cool reading that book. I wasn't already doing everything there, but one of the main things I was doing was the record every deposition and treat each deposition like it is going for trial. Because I would say the reason I think I'm in a good spot for this trucking trial that was supposed to go in 2 weeks is I don't think they realized that I knew what I was doing and that each deposition was getting all my ambitions for trial. And so by the time they kind of picked up what I was doing, it was kind of already too late. They hadn't prepped their people to know that I was actually getting all of these great concessions that I was just going to play at trial. And that's the other thing is the big takeaway is I learned so much about experts during this trial because they hired so many experts and they were just dirty. They were just flat lie. I mean, they just make stuff up. But that plays, that plays for juries because they don't know that this person's a hired gun. What they think is this person's got a medical degree. They look really nice and they're really sweet when in reality, no, they're the scum of the earth and they're just doing this for money and trying to screw over our clients. But that would be my other takeaway is depositions in the expert specifically, you got to nail those because it's either going to lead to a better settlement down the road if you settle your case or at trial, they can't undo the fact that they just gave us a bunch of concessions. Our client was hurt, liability is clear, et cetera, et cetera. If you get all these great concessions from them, what are they going to do? What's their defense? And that goes right in your opening statement.
No, that's great. I've actually taken the position that, I don't necessarily know if I want to do a deposition unless it's something where I know I can push play in a jury trial, right? Like, so not to say that that's the right advice for every case, but
yeah,
I'm a big believer in that everything we should do pre-trial should be with the eye of what does this look like in a courtroom.
Yeah.
And I think that the more that we have that kind of trial ready approach, the more we force ourselves to be more prepared, and the more that we're showing the other side that we're taking this thing seriously. We're actually trying something new, and we haven't done. I just actually finished today. Before filing a complaint, we've not only, of course, have the complaint written, we have our initial set of discoveries, we have our expert designation,
nice.
We have our initial witness and exhibit list with a handful of exhibits. We've got our a bench brief that we file on voir dire. We've got our proposed jury instructions. We've got our proposed verdict form. and I might be missing something, but we're filing all of it and
That's
we're
awesome.
serving all of it. And the thought process is, one, it forces us to not be lazy, to actually do our homework and to make sure that we've got everything in a row. Two, we now don't have to sit to worry about calendaring. I mean, we still will, but making deadlines. And then three, I mean, it shows the court and it shows the other side, like, we're not messing around. Like,
Yeah.
we're ready to go. We're ready to get a trial date. This is a serious case. We've thought through this and we intend to go the distance, right? And so we'll see how it goes. This is the first time that we're trying something like this. But yeah, to your point, it's the pretrial stuff with an eye towards what you're doing in the courtroom really, really makes a difference, because there are a lot of firms, right, Tarun, that, I mean, they file a suit and they think, oh, the offer is just suddenly going to get a lot better. It's like, no, insurance companies aren't dumb. Like, they know how they get insurance.
You're absolutely right. They've got a book, and it's funny. They look it up based on your tax ID, right? And they know who you are. They know if you try or settle cases. I mean, during COVID, one of the things that I really dived into was Doctor. I forgot his name, but he has a lot of the bad faith stuff and suing the Allstate and getting their Colossus stuff. And there was like an 8-part DVD that I got from Trial Guides, and I was watching that during COVID, and I remember thinking, holy crap, like. They know everything about us. They know if we owe money. They know what our liabilities are. They know whether we're a settling lawyer or not. I mean, they know everything about us. It's nuts.
Wow.
Yeah.
Wow. And I mean, and now with AI, I mean, I'm sure they're focus grouping. I mean, yeah, it would be, I think, a mistake to discount how much they know, right?
Yeah.
And yeah.
Yes.
But, I mean, really, if you think about it, like, and I haven't been doing this work long enough to understand the true genesis of why we evaluate cases based on specials. But my guess is that, I mean, it's the only quantifiable thing. It fits onto a spreadsheet, and the insurance companies, I imagine, want to basically assess risk. And so by using those as metrics to value cases, they have, in a way, discounted the real damages, the human losses, and taught a generation or multiple generations of plaintiffs' lawyers that that's how you value a case, is the arbitrary nature of how much a medical bill is.
Absolutely. And I remember that was the big topic, when we were, so Chris and I, when we were younger, we tried a couple cases together, and I mean, small cases, but there was times where we'd be like, don't put in medical because, blah, blah, blah. And sometimes we'd be geniuses. And I remember one where I had 30 offer and I got a 15 verdict and I had meds in. And the client afterwards like, man, maybe if we had medical, they would have given us a little bit more. And it's always tough, right? But you're absolutely right. Like, sometimes it works out great, but then you also hear about plenty of cases where no meds, and then they got, 10 times what the medical would have been. And they wouldn't have got there if they had an anchoring number, right? So
that's right. That's right. No, it's like the classic example is guy loses an eye. Well, not much a doctor can do for you, right? So you got a couple appointments for losing an eye, a couple $1,000s in medical bills. Well, is the full and fair value for losing an eye at no fault of your own worth $4,000? No, right? Like, I mean, it's just not. But actually, that leads me into something I want to dig in. I know you work with the Campbell Group a lot, and you do test your cases. Can you talk a little bit more about, one, what that is, and then two, why you do it so often?
Yeah, I think it's fantastic. So it's John and Alicia Campbell. They I actually, funny enough, I didn't know them while they were in St. Louis, but they're from St. Louis, and it's big data. So what it does is you essentially, it forces you to write the best version of your case and the defenses. So you cannot just, like, it's garbage in, garbage out. So if you don't do a good enough job, you're going to get garbage results. But they're actually really good about helping you do it. But in essence, you argue the best case for you and the best case for the defense, and then they help you kind of using demonstratives or video clips or whatever. But you do a short submission that they then run by roughly 300 people, and there's built-in validity measures to make sure people are answering correctly. But what they do is it spits out like a 50-page report that says, here's the good, the bad, the ugly about your case. But not only that, you get all the people that participated, the people that were for you, you get all their comments as to why they voted for you. And the people that are against you, you see all the comments for why they voted against you. it's kind of nice to see, what the thought process is, but it gives you really good visual chart summaries of like your best evidence. Like, hey, out of the 100 people, like, polled on this topic, 57 really cared about X and the other 43 kind of cared and 2 didn't care, whatever. Like they break it up into good quantifiable data that you can then figure out, okay, if I do my opening statement, I just focus on these 3 topics because the most people cared about those. And this other thing that I thought people cared about, they could care less. So maybe skip that.
Yeah, it's incredible.
Yeah.
The whole idea that you can get insight onto your case before you ever actually bring it to court, right, is truly mind-blowing. And I've heard some say that if you're not focus grouping, if you're not doing some of the big data stuff, then, never heard someone say malpractice, but I've heard people insinuate that you're not far from the line.
Yeah.
I'm guilty of it. I look at the cost of doing a focus group, and I sometimes I wonder, like, is this case is it appropriate to do that? Do I need to? But I do believe, and I hope we get better at it, and I think we will, that if you're taking a case to trial, if you're not willing to spend the few $1,000s to focus group it, then maybe you shouldn't be taking that case to trial.
Absolutely. I would say, so that was another thing with the Keenan stuff was we were doing a ton of focus groups. There were some people that had standing focus groups every week, and it was awesome. I was very proud of our Missouri group because we were so active. The St. Louis group in Kansas City and just everybody in Missouri was just, we were so collaborative, and people could jump in on each other's focus groups. So that was really nice because, you can't really rely on the focus groups for the money part. Whereas with the big data, it is more expensive. Full disclosure, it's not cheap. You're doing it on your better cases, but you are getting not only the issues sorted out, but you're getting good data on actual money to ask for. So you mentioned Ben Gideon and Rahul Rugbrudi. I know with Rahul, a couple of the cases that he's talked about where he got big numbers, like the bouncer case. He put that through big data, I believe, and that gives you the confidence to go in and know what to ask for. And that's what I struggled with my trucking case. I went to ATAA, it's a trucking group, and one of the guys at the end, he's like, "Well, what's that case worth?" And honestly, I gave him a total cop-out answer, but I told him why, and I said, "Listen, I have no idea, but I'm going to do big data, and it's going to tell me." And it's a little bit of a crutch, but it's super helpful to know what your case is worth under what circumstances. Like, it takes the guessing out so you can go in with confidence and know, hey, if I ask for X, they're not going to be pissed off. Or conversely, yeah, they are. Because you see that, so we asked them 3 tiers. And like on one of my cases, when I asked for more, like the higher number, my verdict was actually less than the middle number. So I'm like, ooh, I found the sweet spot. It's middle number, that kind of stuff.
No, we did it once with a bouncer case, and it was immensely helpful. It really was. Ultimately, the case resolved through mediation, and it actually the big data. It was a no medical bill case. Client, TBI, but maintained his job, made a great living, and it settled for almost $1 million. And big data, I think, was a massive part of that because we were able to show the mediator and the defense, like, guys, we're not screwing around. Like, garbage in, garbage out. Here's the write-up we did for the defense case. Like, here, and here are selected comments. Now, of course, we didn't share all of it,
right,
but in working with John, Campbell, and Alicia, like, we did come up with a memo to share, and ultimately it ended up being a case that I think we were ready to resolve. There were some issues that started to develop towards the end that just, it started to call for resolution.
Yeah.
But, well, let's talk about the trial.
Yeah.
Like, what is it about the trial that excites you? And then I'll kind of want to get into some more practical stuff. Like, what's a skill in the courtroom that you think that you'd want to share more about with our listeners?
Yeah, I would say it's kind of like being an athlete. I know a lot of people say that's kind of like that, where like you have butterflies right before, but then when you're in. And that's kind of how it is for me. I get the worst butterflies, but then once I'm talking, I'm pretty natural. I tend to be really personable, so jury selection is my favorite because I'm just spitballing with people. I'm just, talking, and it's a lot of quick conversations, right? And it's really fun. And so that's the part I love the best is when I'm actually in there because I don't have time to be nervous. and And I know it sounds weird, but you just don't have time. You're just in auto mode, which is good, right? That's the whole point of, being in the batting cages. And then when you're playing, a game is you shouldn't have butterflies when you're in the box because you've been practicing all this time and now you're good to go. So that's my favorite part, I would say. As far as practical tips, honestly, it's not sexy, but be organized. I am like super organized. Like I have an entire checklist, and that is my trial checklist where I have like witness so-and-so, it's coming by video. Okay, 43 minutes. And then so-and-so is coming live. Here's their phone number and here's what they're going to talk about. Here's the exhibits that they're going to put in. And why that organization, and then having everything correctly sorted so you're not sitting there wasting the jury's time, and you don't want to waste the jury's time. So be super respectful of that. And I know Joe's doing speed trial, and it's wonderful. The concept is not do a crappy job and just rush. The concept is over prepare so that you can bring the cleanest, quickest trial, right? That's the whole point of speed trial. And that's really what I've taken to heart is put in the prep ahead of time, because then it's going to make everybody know that you aren't sloppy, and the jurors will appreciate it, the judge will appreciate it. And then especially if the defense is sloppy and wasting their time and looking for stuff, it shows that dichotomy of, hey guys, who respected your time and versus who's wasting your time.
Sure. I imagine there's a credibility aspect to it too.
Yeah.
You show up, you're sharp, you're prepared, you're snapping, you're moving quickly, right? Like all of that lends itself to, wait, maybe if I'm a juror, I should trust what he's saying a bit more than the other side just by the presentation and the professionalism, and because ultimately the jury is looking for a guide, right?
Yeah.
Like they don't know as much about the case as we do. And so they need, in some respects, they need to find someone that they trust in that courtroom. And if an organization, I expect, helps with that, right?
Yeah, absolutely. And you're absolutely right. The reliable guide to the truth, right? That's what we always say. Who's going to be the reliable guide to the truth? And I think that's what Mitnick says. And that's what I really strive to do, is always have my credibility. That way the jury's not like, yeah, that guy's sketchy. If he's being sketchy about that, what else is he being sketchy about? So that would be my big tip for trial, is be organized and prepared and have all your stuff in such a way so that you can execute the trial as quickly and flawlessly. Like, for instance, the video depo that's like, okay, 43 minutes. We have a break. Witness so-and-so is not here. Judge, I'm ready with this. Boom, you can slot it in. Or this one's 10 minutes. Judge, you mind if we knock out this quick video before lunch? And we've got 10 minutes. It'll be quick. We get it done. That's one more thing off the plate. And I think the jury sees it and the judge sees that you're trying to stay with, hey, I promised to get this done in 3 days. Here we are.
That's right.
3 days later.
That's right. What does your trial table look like?
Clean.
And tell me more.
Yeah. So I usually have my laptop underneath, because I don't want them to think I'm on my phone. Like I don't, what they're not allowed to do, I'm not allowed to do. So I'm not sitting there on my phone. If I'm on my laptop, I try to step back and go to the pews, like during like the video depots. I have my expandable, like the file, properly organized, and it's either down, or if it's on the table, it's just there. But I mean, there's not stuff everywhere. I really try to keep it clean, because if you keep it clean and organized, it's easier to find when I actually need it. But yeah, I am very neat and tidy. Probably to the OCD level.
Sure. Well, if you're a trial lawyer, there's a little bit of that in all of us, right? So I can tell you, I've got a bag there. It's got my IPVO and all that stuff. I've got my own, my specific Redwell that has specific folders. And so I think you and I would probably fight each other on who could be more minimalist. But
That's funny.
so I've got, but also, like, actually I remember in the Ford trial a few months ago, I had what I needed. I remember my co-counsel was up there and they were trying to use the Elmo and needed like a piece of paper and a Sharpie to draw something out. And I could sense that she was about to start kind of scrambling a little bit because she didn't know where that stuff was. I knew I had my stuff. Like, I know where I have the paper. I've got the Sharpie right where it's supposed to be. Right. And so here it is. And it makes a difference.
And imagine if you're like, oh, hey, here you go. I mean, look at the jury thinking like, oh, this guy's a decent guy. It's not going to be one of these contentious cases where they're butting heads and mad at each other. Because I remember one of the jurors after a case said that. He's like, hey, you guys got along really good, and we appreciated that. You guys worked together as opposed to being, at each other's throats, which was kind of nice. We didn't want to babysit,
That's right. I've actually had both types of feedback. I've had you guys worked well together. It's very collegial. And like, man, you guys were like kids fighting each other in the gym. So I've seen both, but it takes both sides for a trial to go smoothly. It really does.
I agree.
And in many respects, I've found that the better the lawyers are, the better the trial is going to be. It's not good when the skill is mismatched. It's really not on either side. It's painful for everybody.
I sat on a jury, on a criminal jury, believe it or not, and that was one of the big takeaways because I was already doing jury trials at this point, and it was super eye-opening because everything we think they think about, they probably don't think about, and they're focusing on things that I would have never thought. I'm sitting here as a lawyer. Yes, I tried to be in the background. They didn't make me foreman, but like I really tried to let other people talk because I'm like, I don't want to sway you guys. You guys got to do what you got to do, and I have my thoughts, and I'm going to go last. But what's so crazy is there was a huge mismatch between the two attorneys. The criminal defense lawyer was incompetent, was borderline malpractice, but they didn't care. They ultimately were like, yeah, she sucks. Okay, now let's talk about the evidence. Like that was probably the most eye-opening for me because I used to think I mattered in the whole scheme of things, and I don't. I am the reliable guide to the truth and only that. And I'm just conveying info, but they could care less if it's me or a talking head, to be honest. So that was pretty eye-opening for me.
That is so eye-opening. And we all have egos, right? Yeah. And you to some extent, you have to. If you're going to do this, if you're going to stand up in a courtroom in front of strangers and try a case. But the recognition that we don't matter, I take that back. We do matter.
We matter.
But we matter in that the case is not about us. It's about us guiding, the phrase that you've been using. It's about us being that reliable guide to help the jury. One thing that I've started to do, and I learned this, I did an LLM a few years ago at Temple on trial ad, and there's a number of takeaways, but one that I certainly use all the time is I try my best not to say, can you tell the jury this? Can you tell the jury that? It's, can you tell us this?
Yes.
Can you share that with all of us, right? Because as subtle and as small as that is, I think it makes a difference.
Huge difference.
Because we're trying to build this tribe, right?
Yeah.
In a perfect world. So,
and that's been the other kind of path that I've seen a lot more of is, so like Dean Ambrose does it, Sari Delmont does it, but like the trial presentation, I think I did a thing with Jesse Wilson with the masks.
Right.
And I've got both of his books sitting on my table. He's a great guy, and I learned so much from him. But like I've seen more of that crop up where it's and Andrew, did the witness prep stuff, but like where it's more about us and us as our presentation and better ways to say things. And I think that's important too. I think people sleep on that, but I think it's harder for me to like remember like certain gestures and stuff. Like I can't do that. Like I'm not smart enough to be able to do that kind of stuff. But like in general, like the phraseology that you just used, like tell us, like that's really easy to incorporate. And it's like, hey, we're all in this together. You, the jury, and me. We're a team.
That's right. Yeah. No, it's and this is the fun stuff, right? Like this is why we have freaking awesome jobs.
That's right.
So
I agree.
Our listeners are gonna probably tune off as soon as I say this because I've said it like 400 times. But I mean, there's a reason why when my wife is on the couch watching trashy TV like Love Island, I'm on my computer watching Mark Lanier give an opening statement on YouTube, right? Because it's good stuff. It's fun,
right? And
it's rewarding work. Well, I mean, this has been a lot of fun, but we're not done yet. I've got another question. Is that okay?
Yeah.
So we have a lot of young lawyers who listen to this podcast. If you could go back in time to when you graduated from law school and share some advice with your younger self, what would you tell?
Do trials. That is going to be the number one thing. I would say the people that right away jumped in and did trials probably got further along in their career quicker because you don't know what you don't know. And that's actually a big, important thing. I think Michael was talking about how he went to trial lawyers college when he didn't really have as much experience. And that actually was helpful because he wasn't undoing the bad habits. And I think that really resonated with me, because that's what I would say about trial work is you don't know what you don't know, but if you can work at a firm and have a mentor that's going to guide you through a trial and let you actually do it, take all those soft tissue $5,000 to $20,000 cases and go try them, because you're going to get the reps. It's all about reps, right? We as plaintiffs lawyers need to A, get reps, and B, be closers. Okay, a closer mentality, and I'm a big baseball guy, so for me, I think about a closer. Your job is to go out there every night, and even if you get shelled, you got to go right back out there the next time. Same with trials. If you get shelled at a trial, you're going to get zero. I mean, all the good lawyers have been shelled. I've been shelled, and it sucks, but you gotta pull up your pants and go right back in, because that's the only way. One of the ways to ensure that you can do that and have the mental fortitude is go lose some cases that maybe you're supposed to lose, but then go win some of them that you're not supposed to win. And it's going to give you the confidence, but show you how to try a case. So that'd be the number one skill, is go do trials. And this is another one, if you don't mind me throwing it in.
Yeah, no, please.
Especially if you end up, being a hustler like you and I are, you're going to get a big case. The big case, which is a commercial case or a death or something, and you're going to say, listen, I want to do this case myself because I want to get that full fee. Resist that urge at least one time, because if you can bring on a really good lawyer, they should feel obligated to help you learn. They should teach you every single thing. And if they do that, you will get your money's worth, hands down, but you will increase the value of the case. But you got to have somebody who's willing to learn. Don't just find somebody who's like, yeah, I'll take it over. I'm not going to really show you how the sausage is made. You got to get somebody who's willing to be a mentor. And not everybody's willing to do that. My first big case, I didn't have that. The guy just came in and didn't really help me. I then had the opportunity to do that on the flip side this time around, and I got great amount of results in terms of money, but I was very proud of the fact that I walked him through every step so that he could, quote unquote, get his money's worth. Now, was I probably losing money on the deal by spending time teaching? Yeah, but it felt good because that's what our profession's supposed to do. We're supposed to help everybody because a rising tide lifts all boats, right? I mean, we hear that all the time. And I know you share freely, I share freely. Like, we have a great listserv. Get really involved in the listserv. Share your info, because when you help somebody else, they're going to help you when you need it. And the defense does not work together. They don't help each other. They don't know some of the dirt that one of the defense lawyers was able to find it and share it with the other lawyers. Whereas we know everybody's dirt because we all work together. Like, every expert that's a defense expert should be getting lit up because we all know everything about it, which is awesome. It's kind of cool to be able to say.
It's awesome. It's really great. Well, before we close up, and one, it's been an absolute privilege having you.
Yeah.
I'm super glad Chris put us together, and I can count you as a friend. It's awesome. So it's really, really cool getting to know you, learning more about your practice, and then also to have you be willing to make the trip to come out to Richmond here in October, do some training with us. It's going to be awesome. So we're excited for it. We're getting ready, and it's, as you said, the community's coming together for a good cause to learn trial skills. So we're calling it voir dire to verdict, and hopefully it's a good event. But this has been great. So thank you so much for coming on.
Thank you, and it was a pleasure. I'm so glad we did it. It's been awesome getting to know you, and I'm glad to count you as a friend as well.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.